that's going to be arguing, you need to decide in advance how you want to split your time. The appellant's attorney should let us Do you hear me?
We could for a little, and then you went to mute, it says on our screen.
I didn't touch anything. We'll just do a take two and start this over. All right, counsel, we'll try this again. Welcome to the October docket here of the Kansas Court of Appeals. I'm Judge Thomas E. Malone. We also have Judge Anthony Powell and Judge Amy Fellows Klein. We are the panel for the hearings this morning. The panel is here in our Court of Appeals courtroom here at the Judicial Center in Topeka. The attorneys are joining us by Zoom under our court special COVID-19 rules, and I thank the attorneys for participating in the arguments this way. We have 3 cases on the docket this morning. I'll call the cases in the order of the published docket. When I call your case, please give us your appearance, especially if your name is not on the brief, so that we make sure we get that correct for our records. Let me make just a few preliminary remarks. I remind the attorneys that we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind during the limited amount of time that you have to make your argument this morning. As the presiding judge, I'll be the timekeeper. Each party is given 15 minutes for your argument unless it's designated differently on the docket. If there's more than one attorney per side that's going to be arguing, you need to decide in advance how you want to split your time. The appellant's attorney should let us know at the beginning of your argument if you wish to reserve any of your time for rebuttal. After the arguments this morning, your case will be deemed submitted for decision. And after that, we will take the case under advisement and get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll go ahead and call the first case on the docket this morning. It is from Reno County. It's number 123-599 in the interest of N.E., a minor child. And who do we have here for the appellant?
May it please the court, Your Honor, Travis Turnus.
And may it please your court, Mitch Engel from Shook, Hardy and Bacon.
And Mr. Engel, you'll be arguing the case, is that correct?
That is correct.
And then for the appellee?
Or Jennifer Harper for the state of Kansas.
Okay, I had a little trouble hearing you, so you might make sure that you speak up clearly.
Yes, Your Honor.
All right, Mr. Engel, do you wish to reserve any of your time for rebuttal?
Yes, I would like to reserve 2 minutes for rebuttal.
That is granted, and you can begin whenever you're ready.
Thank you. May it please the court, my name is Mitch Engel and I represent the appellant IE. This is a child in need of care case where the child's maternal grandmother and a foster family both want placement and custody of the child. Kansas law says that in such situations, preference should be given to relatives under what is known as the Familial Preference Doctrine. Kansas law also says that substantial consideration should be afforded to grandparents. But the district court judge here seemed determined to have the child placed with foster parents and openly stated that she would not follow the Familial Preference Doctrine. Instead, she disregarded the doctrine entirely, calling it an ill-advised and unproven theory. The district court also never engaged in a best interest analysis, weighing the grandmother against the foster parents because, as the district court admitted, it did not have enough facts to do so. The district court also placed restraints on the Department of Children and Families, what's referred to as DCF, to hamper DCF's ability to make kinship placements. Even after DCF recommended the child be placed with her grandma, the district court overrode DCF's recommendation, took custody away from DCF and placed the child directly with the foster parents. It then denied all outstanding motion, including IE's request for custody, as moot, and oversaw an adoption to the foster parents that same day. The district court's disregard of Kansas law and invention of her own rules and procedures are legal errors that should be corrected on appeal. We are specifically requesting this court, 1, vacate the foster parents' adoption, 2, remand the case to the district court, 3, order the case be reassigned to a new judge, and 4, order that new judge enter a disposition order granting custody of the child to DCF for further proceedings.
Before you get into the merits of your arguments, why don't you start off by addressing the jurisdiction issues that we have in this case?
Certainly, Your Honor. So it's been raised in multiple briefs already, this jurisdictional issue. And so here's the gist of it. In child in need of care cases, parties can appeal, among other things, any order of disposition. So now a disposition order is just an order determining who will have custody of the child. So normally under Kansas law, a notice of appeal has to be filed within 30 days of the entry of judgment. But in March of 2020, the Kansas Supreme Court entered an administrative order in response to the COVID-19 pandemic that suspended all statutory time standards or deadlines. Now, 2 months after that, in May of 2020, my client, IE, filed her motion requesting custody of her granddaughter. Now, it's not entirely clear because the district court didn't do a fulsome analysis, best interest, or weigh the substantial consideration afforded to grandparents when exactly IE's motion was denied. But in January of 2021, the district court said it was just denying all matters still under advisement as moot. This means my client's motion must have been denied sometime between May of 2020 and January of 2021. Now remember, the COVID-19 administrative order was entered in March of 2020, 2 months before IE filed her motion for a change of custody. So during the entire time period that this motion was pending, this administrative order was in place. So whenever it was denied, the time period to appeal was suspended by the administrative order. And so this court certainly has jurisdiction over the denial of her motion. And once this court has jurisdiction over anything, it has jurisdiction over all errors committed by the district court. This appeal.
Let's get back to whether you have an appealable order in the first place. The statutory disposition hearing in this case took place on September 17th, 2019. And that's not even one of the orders that you're appealing. I understand your position that all of these other orders that you are trying to appeal were reconsiderations of the original disposition order. Is that what your argument is?
Essentially, Your Honor, or you could view them as, subsequent disposition orders.
Can you have a disposition order after termination of parental rights?
Our position is that you can, Your Honor.
Well, the NAC decision seems to squarely hold otherwise, doesn't it?
To the extent that NAC holds that, which we don't think was critical to its disposition, we believe it was wrongly decided, that portion of it. But we believe that there's other orders here, including, as I've specified, our client's denial of her motion for request of custody. That is certainly a disposition order.
Well, we can't do much about it when the Supreme Court wrongly decides a case, correct?
That's correct. That's why I don't think you need to address the NAC issue order here, which involved whether an order that is moving custody from DCF to foster parents can be appealed. That's not the only portion that we believe is appealable here. If there was not a disposition order here, then the district court's behavior would essentially always go unchecked. There'd be this ability that the district court has discovered that it can just wait on putting off these type of decisions until later so that the Court of Appeals can never review the legal errors that it has committed. So now I'm going to discuss some of those legal errors. I'm going to first explain what the familial preference doctrine is and how it was disregarded by the district court. I'll then explain what DCF's role is supposed to look like and how the district court improperly limited its role. So in Kansas, the familial preference doctrine is the legal principle that says when deciding to whether to give custody of a minor child to a family member or a foster family, preference should be given to the family member. There are numerous Kansas statutes that also say that substantial consideration should be afforded to grandparents when evaluating custody and placement. DCF's policy and procedure manual also says that relative placement should be given preference. And Melinda Klein, the DCF Deputy Director of Permanency, testified in this case that there's literature supporting kinship placements and that, in her experience, placing children with their family has the best outcomes across time. So following these principles, St. Francis, who's DCF's contractor, inspected and approved IE's home multiple times. And Melinda Klein from DCF and Juan Avicola from St. Francis both testified that placement with IE was in the child's best interest, and DCF and St. Francis would have supported that move. Now, based on...
Counsel, didn't DCF witnesses also testify that the grandmother had expressed initially that she wasn't able to take care of this child, and she'd also supported placement with somebody else?
So, Your Honor, there was a misunderstanding at the first hearing back in September of 2019, an off-the-record conversation between IE and a St. Francis representative. Now, IE always wanted custody of her grandchild, and she showed up at this hearing wishing to express that interest. And she told the St. Francis representative there that, off the record, that she had fibromyalgia, recognized disability. And there's some misunderstanding there where St. Francis seemed to think that she was saying she could not take care of her grandchild because of this disability. And my client, IE, understood St. Francis as saying that she was not going to be granted custody because of her disability. So this was just a misunderstanding that was eventually cleared up with subsequent testimony. So the evidence shows that the note that St. Francis wrote and the district court read was just inaccurate, and that IE is fit, able, and willing to raise her granddaughter. So St. Francis, after this happened, St. Francis evaluated IE's home on 3 separate occasions, and her home passed evaluation each time. IE testified she has never had a stroke, had no trouble keeping up with her granddaughter during their visit together. And at subsequent hearings, both Melinda Klein from DCF and Juan Avicola from St. Francis testified the recommendation would have been placement with IE. St. Francis, found IE had experienced parenting children who are not her own, a support system with friends and family, and recognized that a strength of placing the child with IE was the child would be with her grandmother and be around family. But the district court disregarded Kansas's familial preference doctrine and disregarded St. Francis's recommendation. Now, there are at least 3 separate legal errors committed by the district court that should be reversed on appeal. The first, as I've just mentioned, is its disregard of the familial preference doctrine. The district court referred to the doctrine as ill-advised and an unproven theory. The district court said, an infant placed for adoption outside the system is not, by policy, first held out to family members to assure a guaranteed connection to a biological family. The district court overruled St. Francis's recommendation to place the child with IE, finding the kinship approval seemed, quote, improbable. She said she was basing this on her, quote, assumption that foster parents should be preferred over family members because, in her experience, families involved in the pipeline of foster to adopt are normally younger, healthy 2-parent households. She then said, it would never be in a child's best interest to be placed with a disabled family member if the alternative is a young, healthy family. Now, unfortunately, the district court's decision not to follow the familial preference doctrine is not based on any legal analysis. It is instead based on the district court's personal experiences as a foster mother. As she explained at a later hearing, I'm also an adoptive parent, and I struggle to think that when this baby came to us, we should have put everything on hold to try to see if there was some distant relative or even a grandparent that would be interested in adopting her. The district court, however, must, of course, follow Kansas law. And if this court does not reverse what happened here, based on the district court's own statements and actions, it will just continue to disregard the law and make its own policy decisions here. Now, the second legal error is that there is no place in the record where the district court even attempted to engage in a best interest analysis required under Kansas law. The district court admitted it did not have enough information to weigh IE against the foster parents, and that it knew, quote, nothing about the foster home. And when we tried to cross-examine the foster parents during hearings, the district court said it wasn't relevant to its decision and did not allow the examination to happen. Instead, the district court found IE was unfit based solely on that handwritten note, the misunderstanding we discussed earlier. But it's not proper to base a placement decision on inadmissible hearsay, like a handwritten note. And placement decisions cannot be made on the basis of disability either. Now, the third legal error the district court committed was placing extra statutory handcuffs on DCF's ability to carry out its duties. When parental rights are terminated, the district court can either enter a disposition order granting custody of the child to DCF for adoption and placement, or enter a disposition order granting custody to adoptive parents. The district court chose the first option, but it also created its own rules and procedures. Because of its preference for foster parents, the district court has a standing order that says all kinship placements need to be first reviewed in court or approved by a guardian ad litem. And it reaffirmed its standing order here, reminding DCF that the district court had, quote, added a level of review before kinship placements are allowed. The district court stripped DCF its role because it found DCF was not making reasonable efforts towards permanency with the foster parents, not even considering the efforts DCF was making to place the child with IE. These legal errors led the district court to wrongly deny DCF's recommendations. Now, there are other legal errors detailed in our briefing, but the district courts disregarded the familial preference doctrine, and the placement of improper restrictions on DCF are clear legal errors that should be corrected on appeal. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel. Ms. Harper, whenever you're ready to begin.
May it please the court, Jennifer Harper for the state of Kansas. Well, your honors, I've responded to most of the oral argument in depth in my brief, which all of you have read. But basically, to summarize my response to his arguments is simply stated, when we heard testimony on IE's motion in October, both St. Francis and DCF stated that they would not recommend placement with the grandmother at that time because of the trauma it would cause the child in this case. And IE had repeatedly stated that she did not want placement to St. Francis. That testimony was also heard at that hearing. We had an expert witness come in and talk about the trauma that the child would suffer if she was removed from the only parent she had actually known. In fact, DCF even referred to the parents as the only family the child knows and loves. So, honestly, I would just ask the court to follow with NAC. That decision was rightly decided. And the fact of those cases mirror these pretty closely. A lot of the statements that IE is relying on that the judge allegedly made were made well before the hearing of the testimony or are taken out of context in order to, quite frankly, fit their argument.
What is your position on the timing of the appeal? The Supreme Court administrative order seems to be extremely broad, and it seems like it eliminated all deadlines for appeals. Is the appeal in this case timely? What's your position on that?
Well, part of that's difficult to answer, in part because when the appeal first came forward, it was the state's understanding that IE was appealing DCF getting placement in the first place. However, then in the brief, they stated, oh no, we're not objecting to DCF getting placement. And the two appeals that would have required the administrative order placed the child in DCF custody. So they're essentially trying to use the administrative orders to appeal DCF getting custody when DCF already has custody. And then we're left with the two orders, which in my brief I explained aren't statutorily appealable anyways. Does that answer your question?
Well, it leads to my next question, and that the grandmother is trying to appeal 4 different orders here. 2 of them were after parental rights were terminated, and the other 2 were before termination. And as I understand, the argument is that these are all disposition orders, which you need to have an appealable order. What's your position on that? Were these dispositional orders?
I don't believe so. I mean, if you're going to argue that anything regarding custody is a disposition order, then that means almost every hearing is a disposition order. The statute lays out very clearly what counts as a dispositional order. And although there can be redispositional orders, none of those actually apply here. The argument in regards to the permanency hearing is based solely on a single sentence in that journal entry. But as the Supreme Court has already stated, permanency journal entries are not appealable orders.
Do you have anything further, counsel?
The state would just rest on its brief, Your Honor.
Any other questions? All right, Mr. Engel, I guess it's back for your 2 minutes of rebuttal. You're muted, counsel.
Thank you. I just want to briefly respond to the timing issue. So under Kansas law, there can be no dispute that there has to be a best interest analysis. Now, the district court, the only time it evaluated IE's fitness was before it had any evidence on the issue. That was the order where it repeatedly disregarded the familial preference doctrine. Well, it allowed testimony in subsequent hearings. It never readdressed whether it was in the best interest of the child to be transferred to IE. And at that time, it was relying mostly on this delay in time and the bonding that had happened as its argument of why transfer should not be made. Now, transfers can be made delicately, and that's why we're recommending that DCF be re-involved at the district court level to help this happen in a way that does not cause the trauma. Thank you, Your Honor.
Hearing no further questions, counsel, thank you very much for your briefs and your arguments in this case. And with that, we'll take the case under advisement. We know how important this decision is for all of you, and we'll get that out to you just as soon as we can. And with that, this